Prospecting. A common violation of Utah license law relates to prospecting, finding leads, soliciting for business, or other methods aimed at procuring real estate or property management business. The statute specifically states that a license is required to assist or direct in the procurement of prospects for or the negotiation of the types of transactions we've been discussing. Let's explore an example. A licensed real estate agent would like to use an unlicensed assistant to telephone homeowners who are currently offering their homes for sale by owner. In other words, the home was not listed with the real estate agent, and the seller is trying to sell the home themselves. The real estate agent is extremely busy and wants their assistant to simply make the first contact with the seller. The assistant will ask if the seller is interested in speaking with an agent in regards to listing the property. Does the assistant need a license to perform this function? Let's go directly to the verbiage in the statute. The law states a license is required for anyone who assists in the procurement of prospects for real estate transactions. Clearly, the assistant is assisting in the procurement of prospects, which would need a license. Like other provisions we've discussed, this clause regarding prospecting is also contingent upon the individual in question receiving valuable consideration or compensation, or expecting to receive valuable consideration or compensation. The last role or function addressed in the statute is assisting in closing any real estate transaction. The term closing typically refers to the final stage of a real estate purchase transaction, or the point at which the buyer becomes the new owner of the property. As you might have guessed by now, if an individual receives or expects to receive compensation for assisting in closing a real estate transaction, they will need to have a license. The statute also addresses a few exemptions to this part of the law. For example, a mortgage lender, title agents, or their employees may assist in a loan closing without a real estate license. However, it is important to note that these individuals may require another type of license in order to participate or assist in a loan closing. Exemptions to the licensing law. As in the case with most laws, the Utah real estate licensing law contains exemptions. In other words, some individuals or situations may not require a license, even if the requirements we just finished seem to apply. We will address the exemptions individually. Owners or lessors. If you are the owner of a property and you are selling or leasing it, you may perform any of the functions or participate in any of the activities we have discussed without a license. This makes sense because the purpose of the law is to protect the public. The law assumes an owner will act in their own best interest. Employee of an owner. Previously, we stated that an owner of a property may not hire an employee to perform the types of functions we have been discussing unless the employee was licensed. As we will discuss later, the employee would also need to be affiliated with the principal broker. The statute contains a narrow exemption for commercial or non-residential properties. The owner of a non-residential property may hire a non-licensed individual to perform sales functions which would otherwise require a license. For example, if the owner of an office building wanted to offer the building for sale, an employee of the owner could perform the functions we discussed with the purpose of selling the property. Please note, this exemption only applies to commercial real estate, and the non-licensed individual involved must be an employee of the owner of the property. Commercial properties are often owned by different entities. The individual must be an employee of the owning entity, not a related company, in order to qualify for the exemption. Let's assume Mr. Jones owns Jones Incorporated, which employs many individuals. Mr. Jones also owns a commercial building, but does so through Jones Properties, LLC. An employee of Jones Incorporated would not qualify for the exemption since they are not an employee of the owner. The statute also requires individuals desiring to participate in real estate transactions under the employee exemption to be regular, salaried employees of the owner. The owner must withhold federal taxes from the individual's paycheck. This usually means the employee income is reported on a W-2. The individual may not perform services on a project-by-project basis or receive commission for their services. Property management employees. As stated earlier, the employee exemption we just discussed applies to a sales-related transaction. The statute also includes an exemption for employees of a property owner and for any services rendered which would be considered property management functions. A regularly salaried employee of an owner of real estate may perform property management functions on the owner's properties as long as the unlicensed individual only performs property management functions for one owner at a time. For this exemption, the analysis regarding the definition of a regular salaried employee is the same as previously discussed. The analysis regarding the relationship between the employee and the actual owner of the property is also applicable.